It's week 2 in the federal trial of 3 former officers charged with depriving George Floyd of his civil rights at the time of his death in 2020. Tou Thao, Thomas Lane, and J. King are all charged with failing to provide medical aid to George Floyd. Thao and King are also charged with failing to intervene in Derek Chauvin's use of unreasonable force as he kneeled on Floyd's neck for more than 9 minutes. Here to discuss today's events in court, veteran prosecutor and BNC's legal contributor, Paul Henderson. Paul, this was a third straight day on the stand for MPD Inspector Katie Blackwell, the former head of training for the department. And on cross-examination, the defense brought up issues within that sector of MPD, specifically the DOJ investigation and human rights lawsuit alleging racial bias in the department. The irony here is that George Floyd's murder is what gave rise to DOJ's investigation, and the racial bias they speak of is why, from my perspective at least, why they treated Floyd the way they did, an unarmed black man described as having superhuman strength, but pinned to the ground over a $20 bill that was alleged to be counterfeit.
That's exactly it. And the reason that they're bringing up all of these issues is because as you're discussing and addressing all of the ancillary effects that led to what happened and why we're here in the courtroom, you're not focusing on what the defendants actually did. And I think they're going to keep raising these distractions from the defense team throughout the entirety of this trial. And that's part of why this witness is on the stand for so long. As they drill down into the minutia of what happens in week number 3 of training, what happens on page 724 of that document, you're not focusing as a jury on what did these defendants actually do. And to me, this opens the door again for the prosecution, because they've got the burden, to keep reminding people why we're in court for what these defendants did. And so while we're talking about that 9 minutes with someone's knee on the neck, the issue is, how unreasonable was it for you as an officer to watch someone who was an officer, but even if it was an officer, for you to watch anyone put their knee on someone's neck until they expired? That's the issue. That's what the jury has to be reminded about, and that's what prosecution is going to have to do after they get this witness off the stand, is to remind all of the jury that's why they're paying attention to these details, that's at the core of this, and that's exactly why and how these defendants are being charged.
Paul, the idea of excited delirium, that came up again, or George Floyd's strength being a threat to these officers, was discussed heavily again. Tou Thao's defense attorney showed jurors a number of training videos where excited delirium was covered. But remember, this argument didn't work in Derek Chauvin's trial. And does it even matter when an MPD trainer testifies that Chauvin continued to use force on George well past the point that was necessary, and these officers still didn't intervene?
See, this is why I love you, Yodit. No, it does not. That question does not matter. Not only does it not matter, but it's an insult to the rest of the jury that, again, we're having to hear these made-up, ridiculous things of throwing pasta on the wall, talking about why this is George Floyd's fault as to why he was killed, and talking about the possibility of what he might have done versus what he actually did is insulting to George Floyd as the victim in this case. And regardless of what the potential was for excited delirium, it did not exist in this case. And we know that it didn't exist in this case. You know why? Because we have a 9-minute video showing us all of it. Not the potential of what he could have done because of his size. Not the potential because what others may have done because they had been on drugs or how they were arrested. But this case is about what happened with George Floyd. And there's no ambiguity. There's no need to guess as to what it was. We saw what happened with George Floyd, and these excuses are red herrings for the jury. They have to be reminded and keep focused on what these defendants in this case did not do that contributed to the death of George Floyd. That's it. Everything outside of that box is a distraction and something that the defense is going to try to do, and in this way, a very insulting way, to denigrate George Floyd and to distract for the jury from finding guilt for the absence of action from these officers. That's it. That's what this whole trial is about. Everything else is a distraction, and everything else is a waste of the jury's time from the prosecution's perspective in order to get to a guilty verdict.
Paul, of the three officers, though, Thomas Lane appears to have come the closest at attempting to intervene. During cross-examination, Katie Blackwell addressed that point directly. Lane's attorney, Earl Gray, initially got Blackwell to agree that it was appropriate for Lane to display his gun while approaching George's vehicle. She even agreed that Lane also appeared to try to de-escalate the situation by removing George from the vehicle without force, but Blackwell interjected that above all, quote, he still had a duty to intervene. Why this particular witness is so credible for me is that she's able to concede to a lot of the defendant's or the defense's points. She could say, yes, you're right. Yes, you're right about that too. But overall, what he should have done was physically intervene. And again, Paul, why does any of that matter? Why does anything matter before Chauvin had his knee buried in George's neck?
It doesn't, and you are correct. That is what makes a credible prosecutor. And the things that you are noticing, like I am noticing, are hopefully the same things that the jury is paying attention to as well. But this prosecutor is paying attention, and she is acknowledging that he did some of the things right. And by the way, that's why he's not charged the same as the other defendants. But at the end of the day, he is charged with the other two defendants and is as culpable as they are of not actually taking action to intervene. And when you are an officer and it is your duty to define public safety on behalf of others, including suspects, including people that could be guilty, including people that have committed crimes, you have a duty and an obligation that is absolute to help, to preserve safety. And that's not what happened here. Here, someone had a knee on their neck for 9 minutes and expired because of it. And yes, Lane may have said something. Yes, Lane may have followed some of his procedures and acted appropriately in some of the instances, but we have to look at the totality of the circumstances, and we have to evaluate and judge him and judge the other two for participating cumulatively in police action that resulted in someone dying. This is not a theoretical conversation. This is not the possibility of something bad happening. Something bad did happen. Someone was murdered while you, a police officer, stood by and in part contributed to that death by holding back the crowd and preventing anyone else from intervening and acting collectively and cumulatively with Chauvin. And it's a separate charge, but that's what this whole trial is about.
Paul, please stand by because we're heading to Louisville, Kentucky, where jury selection began in the trial of the only officer facing charges in connection to the killing of Breonna Taylor. We'll be right back.